that case, so go ahead.
Thank you, Your Honor. We have received a copy of the complaint. Mr. Withoff's true name and date of birth appear correct thereon. He waives formal reading of the complaint at this time. He has been advised of his constitutional rights, and the signed acknowledgement of the constitutional rights are in the court file. He has been advised of all possible defenses and consequences. At this time, we will be entering a plea of not guilty, denying any and all allegations, and request the appointment of the public defender's office.
All right, the not guilty plea will be entered. The advisement of rights form is received, and I have it in the file. The public defender will be appointed and shown as attorney of record. With respect to dates, why don't we, before we set dates on this case and take care of the other, I believe there was a motion pursuant to Penal Code Section 1001.95 filed by the defense. I have read that motion. I believe there was an opposition motion filed by the city attorney on that. And did you want to be heard on that?
Yes, Your Honor. As to the 1001.95, these are the arguments that the defense is making. The first is that the charges that have been levied against Mr. Withoff are not prima facie excluded from the statute. The statute has very clear exclusions. None of the charges that Mr. Withoff has been charged with, either in this case or in the new case, appear on the prohibited list of charges. Secondly, Your Honor, the point of the 1001.95 diversion scheme is to recognize that the issue of recidivism needs to be addressed. And Mr. Withoff is a good candidate for the diversion program, fully recognizing that it is discretionary within the grant of the court. He suffered a significant family tragedy, one that has been broadcast internationally, and I cannot imagine what it must be like for someone to see a family member die such a public death, and then to have that broadcast all over the world. That family tragedy has had a deleterious impact on Mr. Withoff's life. He turned to substance abuse in order to cope with the tragedy. He also had to deal with the financial fallouts of that tragedy that affected his business. He has since been sober. He has taken steps to address the underlying issues in this particular case. He attends therapy. I believe he has an upcoming therapy appointment, and he's been attending therapy for the past 3 months. This case, Your Honor, and the new case that comes with it has turned into a significant media spectacle, not because of the nature of the charges, but so much so because of who Mr. Withoff is related to. And this is one of those cases where, if the court were inclined to grant diversion, addressing the underlying issues and recognizing that this is an individual who is still dealing with a family tragedy, that the court should grant diversion in this particular case. And the terms and conditions have been tailored to address Mr. Withoff's individual needs.
All right, thank you.
Thank you, Your Honor. He's certainly eligible for diversion for the statute, but he's far from suitable for diversion. The conduct is really what's most concerning, and I think the court needs to look at the conduct and the history and consider the interest in diversion and weigh those against the societal interests and the people's interest in prosecuting violent offenses, particularly hate crimes. This is not a first-time shoplifter, a young person that just made a mistake, and we don't want to burden that person with a criminal conviction that's going to follow them the rest of their life. This is someone who has had a chance at probation before, and more recently he's got this hate crime offense, and then just a few months after that he reoffends again in another violent attack. So the societal interest far outweighs the societal interest in prosecution far outweighs his interest in keeping his record clean or diversion in this case. So for those reasons, I think he's far from suitable for this diversion. People would submit on that. When the court's ready, I did want to address OR conditions on the new case.
All right, and good afternoon again, sir. So your attorney is asking for diversion under this misdemeanor diversion program, and the city attorney is opposing it, and I have spoken with both of them, and I've read the motion filed on your behalf as well as the opposition, as I said before. This diversion program, as it was alluded to, there's no bright line. There are excluded offenses, but there's no bright line as to who is granted diversion under this program and who is not. It's up to judicial discretion, and I see these cases quite frequently. And they are typically for, as mentioned, individuals who have made a mistake that they would have much rather, in hindsight, wish they had not made. And that may be the case for you, sir, in this case. And there's really, the question is really where to draw the line about who is appropriate for this diversion and who is not. And so the reason I say that to you is because I'm going to deny the request for diversion. But the reason I'm denying the request for diversion is because when I look at your history, and I understand, as your attorney mentioned, I know that there are factors that go into that, and I commend you for seeking treatment to address those issues. But when I look at the history going back to 2016, and then the two incidents that are alleged in the different cases in this case, I just don't find that you're an appropriate candidate. Now, that doesn't mean because I'm finding that you're not an appropriate candidate for diversion that I am making some judgment about who you are as a person. Doesn't mean you're a bad person. It just means that this program of diversion isn't appropriate for you, and you'll have to go on to the regular disposition process or trial if you so choose. So for those reasons, based upon the facts, again, the January 22nd incident that we just, January 13th, 2022 incident that we just arraigned him on, as well as the original incident that took place back in September of 2021, and in light of the 2016 incident, I see a common theme in all of these incidents. And based upon those things, I do not believe this is an appropriate case for diversion, so I'm going to deny the motion.